restorative justice, negotiation, and arbitration. Join an alternative dispute resolution expert, Barrister Ben Odoh, on Settle with Laughter on Soul TV, Abakaliki. Settle Dispute Television is an initiative of Negotiation Powerhouse Company Limited.
You're still watching Settle with Laughter on Salt Television. Do not forget you can watch us on YouTube at Settle with Laughter. The full spelling of the laughter, L-A-U-G-H-T-E-R. We are also on Facebook at Settle with Laughter. And on Twitter, we are at Settle with Laughter, but the laughter is L-A-F-T-A. Okay, laughing the laugh. All right. Right now, we'll take your questions. Do not forget, we'll be leaving here at 10 o'clock. Of course, you can still send questions to 0803 573. That's enough for you to send your text messages only to. Okay. Now, the number for your calls right now on the program will be displayed on your screen in less than a minute. Okay, it's already schools and questions on students, but be guided by the federal government's serious frown against hate speech right now, so that when you call us, you be careful what you say and how you say it. So as we wait for that call, we have this question coming from Professor Don Omale from Sociology Department, Federal University, Lafia in Nasarawa State. The question says, what confidentiality protections exist when ADR is used to address complaints?
Okay. The confidentiality that, thank you, Prof.
Before you take that, let's take this one. Hello?
Hello?
Hello? Can you move away from your TV set? Okay, please, when you want to call us, try to move away from your TV set. That way, we don't get that kind of noise, all right? We get, and then you can hear us and we can hear you. So please.
Thank you, Professor Don John. The confidentiality that exists, it's very simple. You see, when parties enter into ADR agreement, the ADR is characterized by confidentiality. Okay. Confidentiality is the first hallmark of ADR. So when parties enter into mediation proceedings, now at the end of the proceedings, the matter will not be made public, unlike in litigation. Okay. In litigation, judgments reached are published. Judgment delivered by my lord, the judges, are published, and that is why we have law reports. Okay. There is no anything like mediation report. There's nothing like negotiation report. Now, in arbitration, we have a law report in arbitration, but why? If parties are not content with the outcome of the arbitration proceeding, which is the award, they cannot go to court to challenge it. It is that impeachment also that is recorded. Okay. So it is confidential. So now and again, too, as a mediator, I cannot resolve dispute for, you see, some of the scenarios I use here, I don't mention the real names of the parties involved because of that hallmark of confidentiality. Okay. So in ADR, the parties are protected, their confidentiality, their privacy is kept intact, and then is not always made known to public unless they are the ones that want such matter to be made public. Oh, okay. And decisions reached are also not made known to public, except if the parties are contending, having issues, they are impeaching the decisions reached, okay, and they can go to court and it can be made public.
Okay. Hello. 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 Okay, the person couldn't hear us. Hello. Hi, good morning. Can you turn down the volume on your TV set? Turn down the volume on your TV set so we can hear you. Okay, as I turn down the volume, the person they're saying is, when you want to call us, it's either you move out of where you have your television set, okay, or you mute the volume on your TV set so we don't experience that whole back that is deafening actually. Hello.
Hello, good morning.
Hi, good morning. What's your name? Where are you calling from?
I'm Warrior Jacob.
Warrior Jacob from where?
Kaliki Road.
Kaliki Road.
Yeah, 67 in Kaliki Road.
All right, Warrior Jacob, you be our backdoor neighbor. Thank you for joining us.
Yeah, I want to ask,
Okay.
if you have a dispute with your neighbor or your any person around you, then if you want to speak at your area, your neighbor is not supporting you, what will you do to engage the area to solve the problem?
So your question is, if you have a problem, say with your neighbor, but you want ADR and your neighbor does not want ADR, what do you do?
Yes, yeah, what will you do?
Okay, thank you very much. John says, you had his question.
Yes.
What do you do?
You see, everything that has an advantage must have a disadvantage.
Okay.
The disadvantage here is that because of its voluntariness, it's voluntary. You cannot subpoena anybody. You cannot compel an unwilling party to come to ADR table to resolve the dispute with you.
Okay.
So if you call on your neighbor to resolve the matter with you amicably through ADR, and the person says no, you can't force the person. So it must be voluntary.
Okay.
It must be voluntary. The only time it's where I'm talking about voluntary in mediation and voluntary in negotiation and voluntary in conciliation. But if the parties have entered into contract,
Okay.
which is a legally defined relationship, legally and contractual, and along the line they fell out of character, that is a dispute had arisen, and then you are now asking the other party, come, let us resolve our dispute, and he says no, I can't come, when he entered into agreement with you in writing, stipulating in the agreement that in the event of dispute arising out of the contractual relationship, that the dispute shall be resolved through arbitration. And now there is a dispute that is existence, and he refused to come to ADR table to resolve the matter with you. Now you have the right to go to constitute the arbitral tribunal, who will hear the matter in his absence and then give a judgment, whether in his favor or against him. And it will be binding on him.
All right, John, but in this case with your neighbor, there is no contractual agreement or relationship. So maybe now finally court go settle that one. Because
but one beautiful thing about it is that even sometimes when a matter goes to court, I'll give you an example. Currently now we have a law that
we'll take that your example after now. Hello. We're finding it difficult to hear you. Can you speak up? Okay, I'm sorry. We are just finding it so difficult hearing you. Hi, good morning. What's your name?
The guest in the house.
Thank you.
Let me be the host. You are our guest.
This is Ugro from Abakaliki.
You said your name is what?
Ugro.
Okay, S.I. Uguru from Abakaliki. You're welcome.
I just want to ask some few questions.
Okay, go ahead.
Do you have any legitimate right or legal power to compel one of the parties involved in dispute, maybe brought to you, to appear if maybe the defendant in that case refused to appear?
To appear before an ADR?
ADR tribunal.
Do you get my question?
I did. Whether an ADR tribunal or ADR center or ADR expert, whether the person has the legal power to compel an unwilling party to appear before the tribunal. Isn't that your question? Yes.
That is the question.
Very well. The answer is very simple. The ADR, we don't have that legal power to compel any unwilling person to appear before ADR center or before ADR expert. Like I said, it is voluntary. So we don't have any legal rights. No ADR center, we don't have as a center, as an ADR expert, we cannot compel anybody who is not willing to resolve his or her matter through ADR to appear before us or before anybody to resolve the matter. It must be voluntary. The only time, I keep saying this, if it has to do with arbitration, in arbitration, parties go into arbitration through arbitration agreement entered by them. Now, if it is arbitration, now an unwilling party who don't want to appear cannot be compelled by the court. But the only person under the Arbitration and Conciliation Act that can be compelled to appear before an arbitral tribunal is a witness. If that witness, Section 23 of the Arbitration Act provides so, if the witness is a competent and compellable witness, now the arbitral tribunal, what they need to do, competent and compellable. I give you an example, like I said, I've said it before now. His Excellency, the Executive Governor and the Deputy Governor are competent witnesses. They are competent witnesses, but they cannot be compelled because they have immunity covering them. Okay. They are competent witnesses, but they are not compellable. Okay. Now, there are people that are not competent and not compellable. Someone who is a madman is not a competent witness and is not a compellable witness. So, when we're talking about competent witness and compellable witness, is that under Section 23 of the Arbitration Act, if you invite someone who is not a party to the dispute, but who has a testimony to testify before the arbitral tribunal, to come and testify to aid either of the parties, and the person refuses to appear as a witness in the arbitration proceeding, under Section 23, the arbitral tribunal, what they will do, what the law provides that they should do is to apply to the court. And the court will give an order compelling them to and testify under must. In fact, under Section 23, subsection 2, if the person that the arbitral tribunal wants to appear before them and testify is a prison inmate, the law provides that the court will give an order compelling the prison warders, the prison officials, to bring him before the arbitral tribunal, though a private tribunal, to testify. So if it has to do with witnesses, the witnesses can tell us. The arbitral tribunal have the legal power to compel witnesses to appear before them. But if it's for parties, you cannot compel unwilling parties to appear. If a party is supposed to appear before arbitral tribunal to resolve his or her commercial dispute and refuses, the duty of the arbitral tribunal is to go on in the absence of the party and give an award, and that award will be binding. What the court will do is that they will enforce it as the way court judgments and court orders are enforced. I don't know whether you get what I'm saying. Yes. Now. You refuse to come. The court will now send their men
in your absence and then pass it.
Thank you very much. But in mediation, you cannot compel anybody to appear before the mediation panel. In negotiation, you cannot compel. You don't have the legal power. You don't have the legal force to compel anybody. But in mediation, you compel. In conciliation, if the matter is contained in an act, you can compel the person to appear.
Okay. Hello, our last caller.
Hello.
Stay away from your radio set. Okay, did I say radio? That should be TV set.
You're already addicted to TV radio.
Okay, please, where you are, we are looking for that last caller who is going to help us wrap up today's episode of the program. Hello? Hello, can you speak up so we hear you? Good morning.
Morning.
Good morning. What's your name? Where are you calling from? Choma from where? Chama, the problem is we can't hear you. Chama, please, if you're using hands free, can you just get free and talk to us so we hear you? Okay, Chama, I'm sorry, we'll have to let you go. Hello?
Hello. Good morning, how are you?
I'm all right, how are you?
I'm Mr. Peter. Peter Ogoke, calling from Abakaliki.
Mr. Peter, you're welcome to the program. Go ahead.
Okay. I want to ask, if the two parties agreed on settling the matter,
okay.
If the matter is already in the court, can then withdraw the case to settle with either the mediation or the conciliation?
Okay, if two parties are having a dispute and the case is already in the court, can they withdraw it and then settle out of court?
Yes.
Okay.
That is my question.
Thank you very much, Mr. Peter.
Very well. The answer is very simple. Yes. If a matter is in court, parties can agree on resolving the dispute outside court. What they need to do is to notify the court. Please, my lord, give us little time to see how we can resolve this matter amicably and get back to you. What the court do? the court will now stay the matter pending its resolution outside the court. The parties will go out and then see how they can resolve the matter themselves. If they are able to resolve the matter, they will now come back to the court and tell the court that they have resolved the matter amicably, and then tell the court the outcome of their meeting. The court will now adopt the resolution as what is called consent judgment and give it as the judgment of the court. So it's done.
Okay, so when both parties might have resolved outside the court,
yes,
they can now take this.
They will take permission if the matter is already in court. They will not take permission from the court to go and resolve it outside the court. The court will grant them that matter, that application, that prayers.
Okay.
Now, if they resolve the matter, if they are able to resolve the matter amicably, they will now come back to brief the court. The court will now adopt what they have reached as an agreement, which is consent judgment. If they tried resolving it and they are not able to resolve it amicably, what they will do is they will still come back to the court, and then the court will continue from where they stopped, and then give it a full-blown trial.
So what mean they resolve the case outside the court and then don't get back to the court?
No, it's already in the court. And then before you go back to resolve it outside the court, you must take permission from the court because the matter is already in the court. Okay. And then when you are done, you must come back to court to brief them, to tell them, because they gave you that leave, that power, that permission. So you must come back to tell them the outcome of the meeting outside the court. And then the court will see, okay, look at what you have agreed upon. And the court will also want to know whether the agreement was okay, no problem. What will they do now? They will either adopt that as consent. They will adopt that as consent judgment and then give it. There was something because of our time. There was something I was telling you before now. I said, like, now there's a new law that just came in that was just given birth to, just of recent. It's called the National Industrial Court of Nigeria Civil Procedure Rules 2017. Okay. Now, if you look at Order 24 Rule 1 to Rule 12, it provides that when you take your matter to National Industrial Court, in the National Industrial Court, they now have a center in the court called ADR Center. So when you now take your matter to the registrar of the National Industrial Court, they will look at the nature of your complaint. Okay. And then if the nature of your complaint is such that can be resolved through ADR without wasting the precious time of the Honorable Court, they will now refer that matter to the ADR Center in the court. And then the ADR experts there will resolve the matter amicably for you, so that it will not go into full-blown trial. But if they see that, no, it's the one that cannot be resolved through ADR, it will be allowed to go into full-blown trial. You can imagine, you took your matter to court, the first thing they want to do is they want to look at the nature of the complaint you brought before them to see whether they can go through ADR. If they discover that your complaint is a minor or is a trivial one that can be resolved amicably through ADR, they will now refer you to their ADR section in the court, and the mediators there, the panel of neutrals there, will sit down and resolve your matter amicably for you without going through litigation. It's a very good development. Okay. And I say a very big thank you to the president of the National Industrial Court.
Okay, so we're also going to say a very big thank you to you right now, who's been a part of this program. That's today, okay? From when we started today to this very hour, it's been amazing. Keep your questions coming in, keep your comments coming in. You can just send them to the line 0803 509 7383. Again, 0803 509 7383. Just send your questions there. And the last month of September, the last day in the month of September, the last Saturday, August. Of course, September, this one August. So you can send those questions, and the very last day, Saturday in the month of September, we'll come here, and then maybe your question will be one of them. But be rest assured, we must answer your question on this platform. If not that day, some all the time. Okay, do not forget to look out for us on YouTube at Settle with Laughter, on Facebook at Settle with Laughter, and on Twitter at Settle with Laughter, LAFTA. All right, and a repeat broadcast of this episode will be coming your way on Tuesday at 10:30 p.m. For right now, I'm moving the motion that we adjourn until Tuesday. I'll be Saturday. Please concur.
Yes. While I concur and while I leave you with this, Matthew 5:9 says, "Blessed are the peacemakers, for they shall be called the children of God." So if you want to be called a child of God, be a peacemaker and stay out of trouble.
Yeah, borrow a leaf from us. We are the children of God. We'll see you next week. And my name is Abakaliki, and I've been with the professor of ADR, Bernard Odoh.
Thank you.
Thank you.